Hi, I'm Nick Critelli, Chair of the Iowa State Bar Association's Ethics Committee. Recently, we held an internet webinar where we discussed 5 new ethics opinions that deal with business relationships between lawyers. Since the webinar, I've been flooded with requests for a copy of the webinar video. Fortunately, I recorded it. But as you can imagine, an hour-long video is a pretty big file. So to help you review what was said, I've broken it into 6 smaller segments. Now, this is the introductory portion. This is where I give the big overview. I called it the 15,000-foot view to explain how all 5 opinions interrelate. A disclaimer. Please keep in mind when you watch this that the presentation was very much in the moment. It was a live presentation. It wasn't polished. What you will be seeing is a raw presentation. So with that out of the way, let's take a look at the big picture.
On the bar webpage, we're also going to break it down on each one of these opinions, so there'll be YouTubes with respect to all of them. So let's get in our metaphorical airplane and let's go up to that 15,000-foot view and see where we go when we get up into the clouds. As our plane gets up to the 15,000-foot level, we pass several clouds and they all have names. Confidentiality, conflicts, consent, compensation, and supervision. And these 5 concepts will be applicable to all 5 of the opinions that we've talked about, albeit in a little different format. So it's important that you keep these 5 concepts in mind because that's what these 5 opinions are based upon. So let's talk about the first one, confidentiality. At the top, you've got the concept. At the bottom, you have all 5 opinions. How does confidentiality apply to of counsel, pro hoc vici, law temps, mentor and co-counsel relationships? Well, you don't need to be a genius to figure out that confidentiality is the heart of the lawyer-client relationship, and it applies to all of them. There is not one single relationship here where we're not concerned about confidentiality. And you can see as we get into these that creates problems, particularly when we start talking about the law temp aspect of it, and also when we talk about the mentor-mentee, because these are issues that cause problems with respect to how we deal with these relationships. So confidentiality is a critical aspect of what it is that we do. Conflicts. Well, what do conflicts, either direct conflicts or imputed conflicts, have to do with respect to these? Well, it's critical also, but in different forms. So when you start talking about an of-counsel relationship, you got to be concerned about conflicts, direct and computed. Law temps is another big one, direct and computed, as well as mentor-mentee. And how do you deal with it? In some extent, it's been the problem with respect to conflicts that has prevented a lot of people from getting involved in these relationships. In some situations, we have solutions for you. In others, we don't. So the main thing is to make you aware of them, and as we drill down into the opinions, you'll see how that works. Let's go to the next one here. Here's my mouse. Consent. Consent was a big one, and that is, well, do we need the client's consent to use other people with respect to our relationship? Of counsel, notice there's no lightning bolt coming down to of counsel. Do you need client's consent for you to assign a matter to your of-counsel lawyer? And as you can see, you don't. Likewise, mentor-mentee. Do you need your client's consent to have a mentee involved in working with a case? The answer is no, but you certainly do with respect to pro hoc vici, for law temps, and for co-counsel. This law temp one here, Dwight, is a departure from the ABA position. The ABA said no, you really didn't need that. We feel that you do, at least, and as we'll get into that, and you'll see the reason for it. Compensation's another issue. Do you need client involvement with respect to compensation? If you're going to the amount that you pay that person and how they're paid and so forth? Well, of counsel, no, because they're part of a law firm, and you don't need client's consent with respect to what you pay your associates. But pro hoc vici you do, okay? Law temps you do. Mentor-mentee is not paid. Of co-counsel you do. So compensation became an issue, and you can see there's variance there between the 5 different relationships. Supervision's a biggie. Am I obligated to supervise this lawyer? And what happens if I don't? Do I want to take on those obligations? Well, supervision clearly with respect to law temps and mentor-mentee, but not with respect to of counsel or co-counsel or pro hoc vici counsel. And as you'll see when you get to pro hoc vici, it's a little different because you have a couple of other obligations with respect to pro hoc vici that may not be classified as supervision, but certainly by rule are very critical. So that's kind of the 15,000-foot overview.
I hope you found that interesting. The next segment deals with Ethics Opinion 1301, the of counsel relationship. Thanks for watching. If you have any questions or comments, please feel free to contact me at nick@CritelliLaw.com, nick@CritelliLaw.com. Have a good day.